Hi, everybody, and welcome to Last Week Tonight Live. We are here live. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney, and we are here live on this Thursday at 5:30 p.m. So thank you, everyone. So let's get into it. Let's answer some of your questions. We were thinking about actually changing the name because originally when we started the series, we called it Last Week Tonight because we were summarizing all the comments on our channel from the week. So it was kind of like Last Week Tonight, kind of like the other show, Last Week Tonight with John Oliver. So we said we're summarizing the whole week's comments and, responding to our viewers. That was the idea and the name. But now we're doing more of a live where people can join. So it's almost like Law Live. It's almost like, it's not Last Week Tonight, but it's more like Law Live. So we got to come up with a new name. So if anyone has an idea for a name, drop it in the comments or text us. We'd be looking for anyone who has some creativity, has an idea for a new name. But let's get into it. Let's see if we have any comments or any questions right away. I see someone here. Wayne is here. Hi, how are you? And he says, Arkady, thank you again for helping us all. I am simply amazed at your abundance of knowledge and your willingness to share. Wished you practiced here in Arizona. Oh, thank you so much. No, I really appreciate that. Those are really kind words. Yeah, I mean, I try to, answer as many people as I can. Of course, during the live, if anyone has questions, just drop a comment and we'll answer it. And if I'm not live, you could just reach me at 347-566-9595 just by texting me, and I'll text you back and we could schedule a call. I've done a few calls this week. I was a little busy because we have a trial going on in early June. And so this week we had a mediation. We had to go and try to settle the case, before a judge. So we were doing a mediation, and I was also preparing for the trial. And we have some other deadlines, like next week we have some depositions. So we have to prepare for the depositions in various cases, other cases. So it's getting a little busy. So I don't always have time when it gets busy to, to respond, but I'm going to do my best. And I think now we'll see how it goes. It might, the case might settle. So if the case settles, great. They were actually not terribly unfair at the mediation. It didn't settle at the mediation, but the numbers they were talking about were, pretty substantial numbers. So sometimes when you go to these mediations, like I've said before in videos, they just kind of lowball you, and you go in there and you think, okay, I have $1 million case, and they come in and they say, 10,000 or 15,000. You're like, what? What are you talking about? This is not a $10,000 case. And you're just like so far apart, But this one, they came in with what you could say is reasonable. It's a good foundation. So now we just need to get it up a little bit, but it's not. So it gives me hope that the case may settle, because if they came in with those kind of numbers as they did, and then, they just need to come up a little bit more, possibly it could settle. Okay, and then the hire says, what are some reasons for the deposition being postponed? Yeah, so I mean, when a deposition gets postponed or adjourned, it could be a lot of different reasons. So one of the common reasons here in New York is just that somebody is busy, right? Like what happens is originally you go to a preliminary conference, and at the preliminary conference, you just schedule depositions. And let's say I was going to a preliminary conference today. So I would come to court, and my adversary, the defense insurance lawyer, would come to court. And then the judge would say, okay, pick some dates for depositions. So we would just pick some dates. And you're not going to pick a date that's too close, because if you're doing the conference today, you might pick a date like in October, because you need a few, at least like 60 days, 30 days, 90 days, to exchange documents, make sure everyone's ready. If I give them an authorization to get medical records, they need to be able to actually send that authorization to the doctor, and then the doctor has to send them the medical records. So they need time to process all that, right? So then say October comes, and we pick like October 20th. So then October 20th comes, and then for whatever reason, maybe I'm on trial, maybe the other lawyer's on trial, maybe it's just not a good date. There's something else. The calendar clerk put something else on that date. They double book, so that's a common reason. Another common reason is just that something is not done. Like, for example, if a client goes and has like another surgery and they don't tell us, or we don't give the authorization to the defendant, so the defendants don't process the authorization. They can do the deposition without that surgery, without that medical treatment. But the problem then becomes that, okay, you've done it, but it's incomplete. So then they're going to have to do another deposition, you see, and then it's not always good to produce the client twice, because now you've produced the client, they've asked the client questions about what happened, how did you get hurt, what were your injuries, what were your procedures, and you've given them. And now, because there's this other medical treatment that's outstanding, you're going to have to produce the client a second time. And, and now they have two different transcripts. And in and a good lawyer, they'll ask some of the similar questions, and then you have different answers to similar questions. So then it's kind of like, was it this or was it this? And then you can cross-examine on that. So it's probably better to just do one deposition if you can. Okay. But yeah, depositions being adjourned, there's many reasons, but I would say that's usually the main one, that something's not ready yet or that somebody has a conflict. And then Kenzie says, Arkady, we need something on spinal cord stimulator. Yeah, sure, absolutely. I could do a video about that. I could do the medicine behind it, spinal cord stimulator, in terms of like what it is, how it works. And we could also do some verdicts about spinal cord stimulator, like jury verdicts in a particular city, or we could do spinal cord stimulator verdicts, whatever the verdicts are, most recent verdicts all over the country. Absolutely, I'm happy to do that. And then Positive Dude says, can you demand a settlement price? Say they offer 10,000, like you said, can you say like, we want this amount or we won't settle? Yeah, of course. I mean, you could just tell them what the amount is that you're looking for. And you could say, if we don't get our number, then we won't settle, we'll go to trial. You could definitely do that. I mean, the old school way is just to demand, right? So you as a plaintiff demand something. And most people, the old school way was you just demand and you keep your demand, so say for example, if I want to get 10,000, so I would demand maybe like, I don't know, 50,000, right? And they'll say 50,000, that's so much. How about 2,500? That's all this is worth. This is worth 2,500. And then I would say, well, okay, not 50, 40. And then they'll say, okay, 5,000. And you know what I mean? And you just keep getting it until you come to a middle ground. Let's say the middle ground was 9,500, and now I'm at like 15. I'm demanding 15, and they're giving me like 9,500. And then, okay, let's settle it for 9,500. But the other way to do it is just to say, look, I'll give you an opportunity. It's not a demand. It's just an opportunity to resolve this. And it's fair and it's honest. And I believe it's a real opportunity, but I'm not going to keep the opportunity open forever. I'll keep it open, for example, for 30 days. And the opportunity is settle it for 10,000. And you could do that. But if you don't, that's fine too, but it'll expire. For example, it'll expire on, in 30 days. So like today is what, May 23rd. So it'll expire June 23rd at 5 p.m. It'll be gone. So at that point, it won't be 10,000 anymore. It'll be 20,000. That'll be the minimum. But you have to also give them all the medical records, all the photographs, whatever evidence you have to show that it's really worth that money, whatever it is, 10,000, a million, So that's another way to do it. Actually, I like it that way better, because it's more of an opportunity, and you're giving them the chance, and you're giving them everything. And if they want to settle it, they can settle it. And if they don't want to settle it, then okay, but then at least you know where they stand, and then you can go to trial, and you'll do better at, if you feel like you can do better at trial, you could do that. I just don't like the idea of these demands, because, why do you have to demand so high? If you really don't think the case is worth that, why are you demanding so high? And then, invariably what happens is they just say, oh, you're demanding so much, so then I'm going to give you less. And then, I don't know, the whole thing, it doesn't really make sense. The whole idea of demanding something is like I'm demanding, almost like I'm begging, but it's not really about demanding. It's more about putting in an equal trade dollar value on all the harms and losses, because there have been a lot of harms and a lot of losses, a lot of damages, right? Somebody's been really, really hurt. They have a life-changing forever injury. What is that worth? What is the equal trade dollar value of compensation that we could put on that particular change that they did because of their negligence? So that's more of like the question of how to do it. Okay, and then Lost in Awareness says, have you ever had the defense come into mediation with an offer that was lower than what they had offered pre-suit? No, not really. That's not a good sign. I mean, if it was whatever they offered you pre-suit would usually be very low because you haven't even filed the lawsuit. Usually filing the lawsuit gets them to increase the offer because if you're litigating the case aggressively, they're going to give you more. I've never really had them offer less. I don't know why they would do that unless there's something they uncovered, like some kind of real problem with the case, like the case is just terrible or the case has some really big problems. I mean, I've had insurance companies give lower offers, not at the mediation, but just in general. Like I remember one case from many, many years ago, there was a case where a guy said he fell on the sidewalk and they offered him, I think, $95,000, but he didn't take it right away. And then later they got his medical records, and the medical records, he told the ambulance or the hospital that he fell in his own bathtub. So they're like, wait a minute, you said you fell on the sidewalk in the hole. Here it says you fell in your bathtub. So then, of course, they lowered it. Instead of 95,000, they went down. He still settled it because, but it wasn't very good. But yeah, but like that's why they would go down, is because they think the case is is very weak or it has some major problem like that. Like did you fall on the sidewalk in a hole or did you fall in your own bathtub? And it's like so that's terrible. Leonardo says hello, hi, how are you? Vic is here. Vic says awesome. So after 30 days, how is the trial date set? After 30 days. Oh, so no. So what I mean is it's just a way to settle the case, right? So you basically give them a number, like say $1 million, and then you give them 30 days. And the 30 days is just an opportunity to settle. So it's a settlement opportunity. It's like a chance, right? Now they could ask you for more time. They could say 30 days isn't enough. I need 60 days. I need 90 days. Usually lawyers will say, okay, sure, you could take a little more time, as long as you really need it. But it has nothing to do with the trial date, right? The trial date is set by the courts. That's like, it's almost like two parallel things, right? One thing is the court system, and that thing is running, like, for example, depositions, trial, discovery, that's the court. And this is like a parallel, this is just an attempt to settle that's happening between you and them. You're saying, hey, here's 30 days, whatever you need, here are the medical records, here are the depositions, here are the photographs, here's my client's photo albums, this is how his life has been impacted. We think this is a fair value, whatever you want to give them, if you have focus groups or, and then if they say no, then okay, but according to what you put in the letter, it was $1 million by, let's say, May 23rd of 2024, right? 30 days. After that, it won't be $1 million anymore, it'll be 1.5. So if you stick to your guns, then you just have to do that and be like, no, now it's 1.5, and I'm just going to keep going on up, stair stepping on up until I get to trial, and at trial it'll be like 5 million or whatever. That's just however you decide to frame it, however you decide to set that up as a lawyer. So that's not anything to do with the courts. The courts are just doing, they're giving you the trial date that they give everybody. So this is just a way to settle cases. And then Positive Dude says, thank you for answering. Okay, thank you. That's a good question. And Lost in Awareness says, how long does it usually take to get a trial date after the court gives you the notice of ADR? I mean, it's going to be different in every location. Like even here in New York, it's different. In the Bronx, for example, it's not really the ADR. It's more of when you file the note of issue, because filing a note of issue means that you are certifying a case as being trial ready. So ideally, it means, hey, I'm ready for trial. I could even go to trial tomorrow. But because, there's a lot of cases, it's New York City, like, for example, in the Bronx, you could wait 2 years, 3 years to get a trial date. In Brooklyn, used to be 1 year. Now it might be a little bit longer because of the backlog due to COVID, right? Queens used to always be like about a year. Some places it's actually quicker. I believe like in Westchester, it's a little bit quicker, or in Staten Island, it's a little bit quicker because they have less cases out there. Long Island too, Nassau, a little bit quicker. So it just depends, you know. I don't know where you're asking ADR. ADR, I believe, is alternative dispute resolution. So that's a type of mediation. So I mean, in New York, they don't really base the mediation date or the trial date on the mediation date. That's just one of the things that can happen. Like when you're on the trial calendar, they can call you in for a conference, a pretrial conference, a mediation, a possible chance to settle. And if none of those work, then they just give you a trial date. But it's not like the trial date is a certain number of days after an ADR. I've never really heard of that, of them doing that like in New York. Maybe in some other places they do it that way. Maybe in other states. So it would depend. Okay, and then Grethel says, "Hi, Arkady. Hi, how are you? Very nice to see you." Yeah, absolutely. So yeah, let me know what other questions you guys have. Let me see. Maybe I could also jump into the channel here and see if there were any questions in our on our channel. Meanwhile, and answer any questions on the channel. Let's see if we go to content, comments, and most recent. Oh, here's an interesting question. 3 hours ago, somebody says, "What does a client normally do when their personal injury lawyer of many, many years decides he no longer wants to be an associate for his firm and just suddenly quits without one word to you, even though you have a multi-million-dollar case still in litigation?" Wow, so that's interesting. So yeah, so that happens. Basically, what you would do as a client is, I don't know if he contacted you or how you found out about this, but you could either stay with him if you really like this lawyer and he's going from, let's say, firm A to firm B. You could stay with the lawyer and go with him to firm B, and you'll be with at a new firm, but he'll still be your lawyer. That's your choice. Or you could stay with the firm, but obviously since he left, then you'll just get a new lawyer. So it's really up to you as a client. You have all the power. You can choose. So yeah, let me actually. Yeah, so that's basically, yeah, that happens. And then lawyers sometimes get upset and then they sue each other, right? Because if a lawyer leaves and they take a lot of clients, then the old firm is like, wait a minute, but you can't be taking our clients because that's a fiduciary duty. You're an employee. So then there's lawsuits between lawyers, because they don't want to lose the clients. That's a whole other industry, or not industry, but a whole other type of dispute. Okay. And then Derek says, "How are out-of-state surgeries handled?" I'm back again. "Are mileage and transportation costs covered?" Out-of-state surgeries. Yeah, I'm not sure what that means. Like, how are they handled? Oh, you mean like in a personal injury case, if you have a need for a surgery that's going to be done by a doctor that's out of state? I mean, you could do that. I've had clients do that. Like people move, for example, somebody moves to Arizona, right? They get the surgery there. Or, we actually have in our case right now that we're handling, we have a doctor, a New York doctor, radiologist. He kind of semi-retired and he moved to Florida. But he could still review films, right? Because radiology is films, like an MRI. He can still review an MRI from his office or his home in Florida. But now if I need him to testify in a trial, he could even fly back, and just testify. Might be a little more expensive because he has to fly. I could get somebody else who does the same thing in New York. Maybe it'll be a little cheaper, but I don't think it's that big a deal. So yeah, you could choose to do a surgery out of state usually, as long as the doctor is able to testify, as long as they're a licensed doctor. and they're a medical doctor and they're able to testify in the host state where you need them. You have to make sure they're able to testify in that state where you need them. But for the most part, it should be fine. The only time I've kind of heard of that issue maybe come up is in med mal, because in medical malpractice, you need a doctor who's familiar with the standard of care in that community. So in that community could mean specifically, you know what I mean? Like standard of care in New York City could be different from the standard of care in some town in Oklahoma, right? So if you get that doctor, perhaps that could be an issue. I'm not, but otherwise, I think it's fine. I think it's fine. Yeah, people get surgeries all over. People get treatment all over. All over. People move, obviously. So that's you just have to kind of take care of all that in terms of logistics. Okay, and then Wayne says ACDF, spinal cord injury. I think he means myelopathy, right? Myelopathy in both arms, or myopathy in both arms. Have an independent witness. Low speed rear end crash. He claims I backed into him. Settlement value. I mean, it's hard for me to say. I don't know the settlement value out in, I think this is Arizona, right? I'm not familiar with the values out there. But I can tell you based on New York, I mean, look, if you had an ACDF and a serious spinal cord injury like that, and you have an independent witness, I think the main thing is going to be the fact that it was a low speed crash. They're going to say that at that low speed, you could not have sustained this type of injury. So you're going to have to deal with that, whether they're going to have biomechanical engineers. You may need to get one too, or if you have a way of cross-examining their biomechanical to discredit that witness without using your own witness, that could be the other option. And then, of course, you're going to need good doctors like radiologists to show, look, this looks traumatic on the film. This herniation is not degenerative from living your life, because they're going to say, look, if you have the herniation and you need a ACDF, but it's a low-speed little fender bender, it's not from this. You already had it from living your life. It's degeneration. So you have to look at the film and have the radiologist say, no, that's not degenerative. That's actually traumatic. Or it could be degenerative changes, but there could be trauma that aggravated and exacerbated the degeneration. So basically, everybody has degenerative changes, right? That just means you're living your life. If you didn't have degeneration, it would be amazing, right? Because it would mean you're a baby. A baby, when they're just born, right? They're, what are they, 8 pounds, and they're just born. They're a few days old. They don't have degeneration. Everyone else does, right? Like I do. Everyone who's in their 40s, 50s, 60s, 70s is going to have some degeneration. It's the painless, normal painless aging process, right? It's a process. So that's all you have to show is like you're going through the process. Of course you are. And then the trauma just aggravated the process. The trauma made the process worse. So yeah, as long as your doctors and your lawyers are on board, you should be fine. I mean, it's hard for me to say exactly, what the settlement would be, but if you have that ACDF, it should be either in the high 6 figures, right? Like something like 400,000 or 500,000. And that would be probably if the case has problems. And if the case doesn't, it could even be into the closer to $1 million or more. Okay. And then R. Peterson says, hello, Arkady. 3 days after my accident, I received a phone call from the defendant's insurance company. He had a lot of questions for me to answer. I'm just curious, why do the insurance companies get in touch with you? Is it because they're trying to get more information on the case, or are they contemplating making a settlement offer? Yeah, I mean, they're really like managing risk. So they want to like know about the case to understand everything. And mostly it's managing risk in terms of getting, like, say, a recorded statement. And if you say something like, oh, I'm fine, I'm not hurt, and then later you do get treatment and all of a sudden you do get hurt, they can maybe try to use that against you. So there's a lot of pitfalls. I mean, mostly I would say it's to manage their risk. It's not I mean, depending on the type of case, sure, they do speak to some people and make some people offers, but usually the offers they make are small, small offers, like $500, whatever. Very, very rarely do they offer like full value or anything approaching full value to injury victims, especially if those injury victims are on their own, by themselves. So, yeah. Meaning without a lawyer, they're not going to offer much. Okay, and then Derek says, do you work with doctors to help figure out a future plan without a life planner? For example, 30 years from now, needing a mobility scooter. Yeah. I mean, yeah, doctors can do that. I mean, life care planners do that too. So you could do it either way with a life care planner or with a doctor. Yeah, I mean, doctors sometimes can just talk about cost of medical care into the future. And so whether it's equipment like a scooter or whether it's just like physical therapy visits, because they're doctors in the community, so they could give that opinion, right? They could say, for example, one physical therapy visit is $100, but you're going to need one for your lower back. You're going to need one for your neck as well. And then an economist might say, okay, what's the present value of that? What's the future value of that, considering inflation in the next like 30 years, and project all that, and then it all adds up, and then you have all the numbers that you can obtain. Okay. And Lost in Awareness says, do you believe that it hurts your case if you're coming off as eager to settle? I mean, it could, yeah. If you're coming off as too eager, sure, right? It could definitely hurt. I mean, it just depends on how everything is played out and how everything gets handled. I mean, of course, if you come off too eager, if you're calling them every day, oh, do you have any money for me? Do you have any money for me? And they're just like, no, no, or we have to review it, and you just, that's going to look kind of weird, like you're too eager, and they're not going to give you full value. So I don't recommend that, of course. And the whole idea of demands, I mean, people sometimes call and make sky high demands and just say, oh, I'm demanding $1 million. And then they'll say, you know what, that's just way out. We're not even going to make an offer against that demand, because we don't see it as not only not $1 million case, we don't even see it as a six-figure case. We see it as a, $10,000 case, for example. Why would we even respond to $1 million demand, right? So then you're just kind of way too far apart. Or you could do it the other way, like where you just tell them, hey, this is a fair number. Here's your chance. Here's your opportunity to settle it. Here's your time frame, and let's try to settle it. If we can't, okay, then we're going to, then you make it easy, right? Then we're just going to go to trial. So you have to really be ready to go to trial and not be afraid of trial. Okay. And then Derek says, if you see settlement offers go from 29K to 63K to 280K on the third offer, what would that mean to you as far as maximum value? Well, I mean, definitely it's going in the right direction. I believe this might be a workers' comp, though, right? Because I'm not too familiar with workers' comp. Like I've said, because I do the personal injury. But in a personal injury context, I mean, if they went from 30 to 60, they doubled it, right? And now they went to 280, so they tripled at 60, and they've 10x the 29, right? So that's a good sign. I mean, it's hard to say what their final is. Usually, they tell you if you're going to play that game with them and just wait for them to keep going up. I mean, at a certain point, they'll probably say, okay, that's it, right? That's our final. Because like if you play the old game, like whatever, if you start at $1 million and they start at 10,000, and then it's just you're trying to get to a middle number, right? But what's the middle number going to be? It may be 500,000. It might be different. They might say, oh no, you have to. We can get you like 200, but you got to come down and demand, 250. So then you come down and demand 250. Well, now you've lost the 750, right? But forget about the million, because you can never go back up when you're demanding. So forget about the million, forget about 750. That's gone. Now you're at 250. And then they'll say, okay, now we give you 200, and they'll settle for 200 or maybe 225 or whatever. You know what I mean? That's just how they negotiate. So it just depends on how you want to do it. If you want to do it the old school way or you want to do it the opportunity way, it's really up to you. But I mean, you and your lawyer, uh, if it's a good case and you're willing to take it to trial, maybe do it the new way. I think it's better because you're giving them an opportunity. You're putting a fair number in there. You're not putting in a crazy number, right? And then you're saying, look, if you don't pay it, that's fine, but then we're going to go to trial. And then you have the real threat of trial. The other thing you could do is bad faith, and they have a duty of good faith and fair dealing to their policyholder, right? Which is their insured that's paying those premiums. So yeah, you could use that against them too, that they're not protecting the policyholder. Because if you're giving a number that's within the primary limits, for example, if the limits are $1 million and you're saying I'll settle it within $1 million, and you have 30 days, so you can make this go away. For example, for 850 within or $1 million or 850, whatever, 750, but within the primary limits. But if you say no and you let the 30 days elapse, then it's going to be 1.5. So then if I do get the 1.5, who's going to pay the difference? Is it going to be the policyholder, the person who's paying for this homeowner's policy, or the person who's paying for this auto policy with Geico, State Farm, Allstate, Progressive, whatever? How's that fair to them? They're paying for protection, for insurance, and you have a chance as the insurance company taking these premiums, you have a chance to settle within the primary limits, even under, right, like 850. But you're saying, no, we don't want to do that. So then you're gambling. And if the jury says 1.5, who's going to pay the extra 500? Are you going to pay because the policy is now open, or are you going to make them pay it? And then a lot of times what happens is the policyholder can sue the insurance company for failing to protect them because there's a good faith and fair dealing, and they have to put the policyholder's interests on an equal footing with their own interests, meaning the insurance company can't say, oh, we're an insurance company, we're $1 billion company, we care about ourselves up here, but these policyholders that pay us every month, we don't really care so much about them, let's put them here. They have to, the law says they have to be on an equal footing. The policyholder and the insurance company have to be on an equal footing. The insurance company can't, just take their premiums and say, we don't care about you. So there's a lot of things you can do with that. Okay. Truth Seeker says, good to see you, Arkady. Question, does medication being prescribed increase your settlement, like being prescribed fluoxetine and buspirone after TBI? Yeah, definitely. Any kind of proof that you have a TBI, like the scanning, the neurological doctor, the diffusion tensor imaging, MRIs, neuroradiology, neuropsychology, and then the fact that you're taking these medications that are known medications that people with traumatic brain injuries take. Yeah, I think that all helps. It all goes to prove that you have a true TBI, and it's going to be worth a lot. And then CC says hello. Derek says, good speaking with you again. Yes, very, very nice speaking with you. Asedzi says, what comes next after serving defendants and finally getting in contact with a lawyer, talking about settling out of court before court again? What comes next after serving defendants? So when you serve them with the lawsuit, they usually appear, they answer. It's called an answer, but it's just like basically a verified answer. So it's like you file the lawsuit, they give you the answer. That's the next step after the lawsuit is the answer. It's just an appearance, really, because they say we deny, or we deny information or knowledge. So basically they're appearing in the case. And once they appear in the case, then you can go see the judge and have a preliminary conference. And then Derek says, settlement opportunity letter, LOL. And Cece says, oh yeah, this was the question I just read from the channel comments. Okay, my lawyer who quit was an associate, and now the partners are taking my case, and they say it doesn't matter that my lawyer left because I won summary judgment. They would have taken over either way. Oh, okay. And he says, if my last lawyer gave a demand of 12.5 million, can I now ask for more with my new lawyers, even if they were the same firm? Well, if it's the same firm, it's going to be tough to ask for more. If it's a new lawyer, then anything goes, because the new lawyer could have reviewed the case and just given their own assessment. But the same firm, they usually hold you to it. Although sometimes you could, but it's not that easy, basically. If you want to settle, if you want to just kind of like, you can demand anything, right? But then they might say, okay, but that's pie in the sky demand, and then you have to go to trial. But if you actually want to get them to settle and you have the same lawyer, maybe you have to, keep the demand the same. But 12.5, that's a pretty good number if they're going to pay that or anywhere close to that. That could be. I don't know the facts of the case or the injuries, but feel free to text me at 347-566-9595. Happy to do a chat and just give you my opinion. Okay, and then Big Mac says, do you think the juries would view you as too litigious or looking to win a lawsuit lottery if you have multiple petitions on record? Wife had a wreck, I had a wreck 8 months ago, 8 months later, 2 lawsuits concurrently. I don't think so, not just from that. If you had a lot of lawsuits, let's say, I don't know, 7 or 8 lawsuits in a short time, like in 3 years, maybe. But if you had one and your wife had one, that doesn't really seem as litigious. Especially if they're both serious wrecks and you have serious injuries. that's just like, I mean, bad luck, but it's two different people. So I don't even know how they would get that in evidence, because unless your wife is also suing in your case as a loss of consortium, but even then it might not be relevant because if you have a case, that's your case, right? You're suing for the injuries for that case. So the fact that someone else in your family also had a personal injury, that should really stay out of evidence. That's more prejudicial than it is probative of any issue. It doesn't really prove or disprove any issue in the case. So I don't see how that even comes in. Most likely, you can do a motion in limine and exclude that about your wife's case. So it'd really be only your case. And then who are you says, when will the lawyer make an appointment for the hearing? After the deposition is completed, that is when will the hearing date be determined if going to court. Oh, I don't know, but what kind of hearing? Hearing for what? I mean, if you're talking about a trial date, then I would say the lawyer doesn't make the appointment. You just basically, the deposition is all part of discovery, right? So discovery is like what happens after you appear. Like I was saying, the defendant appears. That's called an answer. You file a lawsuit, they appear. Now you have all the parties are in the case. That's called issue has been joined or issue. That's what they call it in New York. But basically, everybody's in the case now, right? Because you can't have a case. You just have a lawsuit, but there's no one else, right? So you can't have. You have to have the other people appear. Now they've filed their appearance. They've answered the lawsuit. Now you have everybody, right? Maybe one defendant, maybe two, three, whatever. Everybody's in the case. It's like a party. Everybody showed up to the party. Now that everybody's there, you go see the judge, and the judge says, do discovery. Exchange documents that are relevant, take depositions of parties and possibly of non-parties that are relevant. Once all discovery is done, the depositions and the documents, then I'm going to put it down for, going to go on the trial calendar, and then you get a trial date. That's going to be the final date so that's all set by the court. And then Derek says, glad I could keep you busy for a couple of minutes. Haha. Oh, yeah. No, absolutely. Anytime. Yeah. Feel free to text me as well. I think we were going to do a call, right? Or do like a video at one point. Yeah, maybe we could still do that this summer when things slow down a bit. I think I have this case that I'm doing in early June. We had mediation this week. But like I said, it went well, mediation. They were offering substantial amounts already. So I'm hopeful that maybe the case doesn't have to go all the way to trial. Because the thing with these cases is, like, I want to take them to trial. I like the cases. I think we can do well at trial. But the problem becomes you want to do what's best for the client. So, for example, if I go to trial and I'm stuck in a trial for like 2 weeks, right? Then okay, I do a good job. Even if I get a big verdict, let's say I get, I don't know, 7 million, for example, right? But then the other side is just going to appeal. And the appeal is going to take 3 years. And then the appellate division may say, you know what, 7 million, that's too much. Do another trial. So then I'm back at square one. So then what's the point of it all, Or they could say, oh, 7 million is too much. How about you take, 2 million? But then I could probably get that much or close to that as a settlement without even going to trial. So then you see what I'm saying? So you have to think about all these logistics as a lawyer. And also you have to think about, okay, but if I'm in trial, let's say for 2 weeks, then obviously you can't do other things, right? Like you have other clients you have to attend to and other work and other people you could be helping. So it's always like you have to consider everything. But I was hopeful about that case. I think it's going to go well because like I said, they were very reasonable with the initial offers, and it wasn't quite enough. But I feel like if they come up a little bit more, it could be a case that's settled. And also, that's the really good thing, right? Because as opposed to getting a big number, people want to get big numbers like 20 million, 30 million, but then they'll just appeal. The appeal will take 3-4 years, and then you're not going to actually see that money. So it's just a piece of paper that someone says, oh, it's worth 20 million, but you don't actually see the 20 million. And this way it's an actual settlement. It's actual guaranteed money for the client. So it's much better in that sense. Okay. Let's see, what question are we up to? Lost in awareness. In what ways, without causing a mistrial, do you hint to the jury that the insurance is paying and not the person being sued? Yeah, I mean, you're not really supposed to mention the word insurance, but I haven't really ever done it or even thought about it. Maybe thought about it, but I haven't really ever done it in court. But I mean, most jurors will know that insurance exists, right? And they could bring it up. Like a lot of the time when you're doing the jury selection and you have the panel, right? Let's say you have 20 people in a room and you're doing the jury selection, you're talking to like the first 8. That's the way they do it in New York. You talk to the first 8, but the other people are there listening, and there's like 20 or maybe 25 people in the room. So then you're chatting with all these people. And then when you talk about things like car accidents, when you talk about safety, whatever the topic that comes up in the jury selection, somebody might say, oh yeah, wasn't insurance cover that? And you can't really stop them from saying it, right? But you're not supposed to say it as an attorney. If you bring up insurance, it could be grounds for a mistrial. But if you feel like you can get them to say it, that's okay. And and even if they don't say it, I mean, everyone knows that there's insurance, right? I mean, you see the ads, the State Farm, like a good neighbor, Allstate, you're in good hands, the Gecko, the Progressive lady, Flo, or whatever her name is, I mean, everyone knows insurance exists. I don't think, do you think anyone really thinks that, let's say, if I'm suing, I don't know, my client got hurt, he got into a car crash, she got into a car crash, and there's like the other lady who's driving the car is like this little old lady. Does anyone really think we're suing the little old lady and we're going to take her house and she's going to be homeless because of this? I mean, I don't think anyone believes that. But I guess one way you could do it, I mean, this is off the top of my head, but one way maybe you could do it is you could talk about like corporations or corporate interests, or you could say, what if there's some company behind all this, right? A company or a corporation that's really pulling the strings. And, people think they have a trusted relationship with this company. They rely on the company. They believe in the company. They pay money to the company because of this trusted relationship. But then when it comes time to actually step up, the company disappears. The company says, no, we're not going to take any responsibility. We're not going to take any accountability. We're just going to blame you. Blame, you're not really hurt, you're this, you're that, point the finger, which is basically what they do, right? So it's almost like a betrayal theme. And a lot of the good trialers, they use that theme of betrayal in a trial. So that might be one way you could think about doing. That's a good question, actually. We should think about that. And then Steven says, hey, signing in showing support. Talk with you soon, boss. Oh, thank you so much. Yeah, thank you. Hope you're doing well. And CC says, and if I want to leave, will that be a problem? Oh, I see. Leave the firm and go with the original lawyer, go to the new firm that he went to. I mean, it's hard for me to say, depending on, who you feel more comfortable with. If you feel like that lawyer is better for your case or his new firm is better. I guess if he was the one handling the case, then it could be okay. If you feel like he's competent and he was be able to take care of everything. But feel free to text me, I could just give you a free consultation or chat and give you my opinion. Also, what I've been doing for some people, like I've said before, is if they have a question about like this lawyer, I have this lawyer X, are they good? Are they, you could do some searches like in Westlaw, Lexis, or Jury Verdict Reporter, and you could say, hey, lawyer X, yeah, they're good. They have $1 million here, $2 million there. Or sometimes you think, hey, they're good, but then you do search, wait a minute, they have 2,000. Ooh, that's not good. 3,500. Oh no, and then 0, 0, 0, 0, 0. And some people don't have anything. They think, oh yeah, I have this guy. He's a real trial lawyer. Oh yeah, John Smith. And you do the search, and then it's like nothing, crickets. So obviously, wait a minute. If they're a real trial lawyer, how could they not have any results? So okay. Let's see. Asedzi says, defendant passes away during my personal injury lawsuit. What comes next? So you would have to appoint somebody as administrator of the estate and then proceed against that estate. So it's like a surrogate's court. In New York, they call it the surrogate's court, but it's the Estates, Powers, and Trusts Law, the EPTL. So it's like you probably have to get either a lawyer in your firm that's familiar with that, or there are actually lawyers that specialize in wills and estates and trusts and all that stuff, and they could do that for you. It's a little bit of a process. It's slow, unfortunately, but you have to get that done. Kevin says, how long will it take to get going on my case since I'm currently 100 days since the accident, 95 with the firm? injuries are 4 bulging discs, 3 protruding, moderate TBI, and tears in the right knee. A semi hit me in California. I've gotten 2 injections in the spine for pain pending surgery. Should I expect years? I mean, yeah, it's going to take time. If you haven't finished the medical care, you can't really think about settling the case. The first step is to have all the medical care and finish all the medical care, right? Because once you finish the medical care, then you get all the medical records. Then you file the lawsuit. You could send the medical records to the insurance company. You find out how much they have, what's their primary, what's their excess and umbrella, and then you could say, for example, I had this type of surgery. Here are all my medical records. I know you have 3 million total excess and umbrella. That's all you have. There's no more, right? And my demand is, or my opportunity is, whatever, 2 million, or whatever you put in the letter. And you have 30 days. Let's settle it like that. But to do that, you have to have all your medicals available, and you have to be done with your treatment. So yeah, I mean, but litigation-wise, it could take some time. It could take a few years if they're going to litigate it. If it's a big policy, if it's a semi-truck, depends. Sometimes the semi-trucks are like owner-operated, like one person owns them, and the policy is smaller, like 700,000. Other times, there's a policy that's bigger. It could be a bigger company like JB Hunt, or sometimes it's like a Walmart or an Amazon truck, right? And there could be layers upon layers, and there could be like 10 million, 20 million, which is better for you, but then it might take longer. If you're trying to get the big money, you have to litigate to get it. They don't like to just hand over the big money. Okay, and then Derek says, yes, we will do that. I was hoping to settle before I started talking about my case, but I have nothing to hide. I will definitely call you to set it up. Oh yeah, the chat, yeah, we can do that. Yeah, maybe after, that's fine too. And KCD Star Biker says, Arkady, hi, how are you? Thanks for all you do. Your audio is choppy today for some reason. Maybe it will be okay post live once it posts. Oh, really? The audio is a little choppy today? I don't know what it is. Maybe it's something with the mic. Let me see. I'm not sure. Yeah, I don't know. I'll try to fix it. Yeah, maybe it's something with the mic, because I think the mic today, maybe it was from my camera. I have this new camera. It's like a tracking camera. It tracks you. Maybe there's an issue with the camera. I'm not sure. It's plugged in. Maybe. I'll take a look. I'll try to reset it. And who are you says, if we cannot agree after the deposition is completed, how long does it take to go to trial for New Jersey? I know you're in New York, but maybe you have a guess, and thanks for replying. Oh, okay. How long does it take to go to trial? I think New Jersey is fairly quick. So if New York is about a year from note of issue, New Jersey, I believe, is even shorter. New Jersey should be fairly quick. I think it's shorter than New York. And Chris says, hi, thanks for all the videos. I was on a commercial accident at work, 2022. I was also in a commercial vehicle. The other person ran a stop sign and totaled my water truck. I went back to work light duty a month later when I was hit again as a passenger with a car. Will that affect it at all? No, it should be fine. I mean, as long as you could show what the injuries were from the commercial accident at work, and as long as the injuries aren't the same, because if the injuries are going to be the same from the other case, with the the second case, then it can get confusing, because they could be like, well, what's the injury from? Is it from the first case? Is it from the second case? But as long as you can keep the injuries separate for the two cases, I don't know if you're pursuing both cases. I would just focus on the one case and just make it clear, like, these are the injuries from this case, those are the injuries from the other case, just so it's separate and distinct. And Derek says, can you see workers' comp results? No, I can't really see that. I only see the personal injury cases. And then Wayne says, thanks. Yes, myelopathy. My doctor records say no history of pain or injury. The surgeon said I am an eggshell patient. Another doctor said the MRI may show possible trauma, some aging-related DDD. Oh, I see, right. Yeah, I mean, like, 70, okay, yeah. I mean, eggshell, yeah, that's definitely eggshell. So, but you take your plaintiff as you find him or her. It's as is, you know. You don't get to say that, like, for example, if you're, let's say, you know, I don't know, one lawyer uses this analogy. He says, imagine if I was, you know, driving a truck, and in the back of my truck I had eggs, and somebody rear-ended my truck and all the eggs broke. Does that person then get to say, well, why were you carrying eggs in your truck? You should have been carrying ping pong balls. If you were carrying ping pong balls, they wouldn't have gotten broken. You would have been fine. No, you don't get to say that. It's just you take your plaintiff as you find him or her. It is what it is. Some people are more susceptible. Like if you're 70, you're an eggshell plaintiff, you get hit even in a low speed, you could have a serious life-changing injury. Someone else who's like really strong, some kind of bodybuilder at 20, you know, the same impact, they wouldn't even get out of the car. They'd be like, okay, whatever. And they just keep going and nothing would ever happen. They wouldn't need an ACDF, right? So that's what you have to do. Okay, thank you, everyone. Thank you for being here. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families, helping people like you. Just text us, 347-566-9595. Here, I'll drop it in the chat. And yeah, we are here for you. All the best. I have to run, but we are going to be available and you know, happy to chat further. And we will be doing some more videos next week and maybe some more lives as well. Okay, all the best. Bye-bye.